Ms. Gutierrez-Reed should be entitled to a new trial with instructions that are different, that follow Taylor and they track Taylor's language, requiring a unanimous verdict on the specific act that she alleged to have committed.
That's attorney Jason Boles fighting for a new trial for his client, Halyna Gutierrez-Reed. I'm Imran Ansari, walking you through the latest hearing in the Rust movie set shooting saga out of New Mexico. Let's jump right in and listen to more of Gutierrez-Reed's attorney in this virtual Zoom hearing from Friday.
I wanted to touch on some principles in the Taylor opinion this morning and also the Godoy case in light of the jury instructions provided at this trial. Judge, at the time of trial, none of us had the benefit of the Taylor opinion, which, as this court knows, came out after the jury verdict. So I first want to talk about the jury instructions given, which this court is aware. There was a jury instruction given in 12A that gave the jury two alternatives connected by an and/or connector. And those two alternatives were the alternative theories for involuntary manslaughter that the state had advanced at trial. So the instructions provided that the jury could find Ms. Gutierrez-Reed guilty under either alternative theory connected by an and/or. Following the jury verdict,
Gutierrez-Reed was convicted in early March on involuntary manslaughter charges. Her case stems from the death of cinematographer Halyna Hutchins in October of 2021 on the set of the film Rust in Santa Fe, New Mexico. Actor Alec Baldwin, who was also a producer on the film, was rehearsing on set when a live round was discharged from his prop gun, killing Hutchins and injuring director Joel Souza. Baldwin will face his own trial in July of this year when he goes on trial for the same involuntary manslaughter charges as Halyna Gutierrez-Reed. In the meantime, Gutierrez-Reed and her defense team argued for a new trial and her immediate release from custody ahead of her upcoming sentencing. Here's more of what her attorney told the judge on Friday, citing a New Mexico court case that reversed a jury verdict due to an error in jury instructions.
Our argument under that principle is that we had two different acts in this case. The first act being that she loaded a live round into a gun that was supposed to have inert ammunition. And the second act was that she did not allegedly perform an adequate safety inspection of that firearm. Based on those two paragraphs in Taylor, there should have been separate instructions, and there should have been the requirement that the jury unanimously find which act it was, which theory it was that they said she committed. The problem with the verdict under Taylor that we have at this point is we don't know which act the jury may have found unanimously or whether it was unanimous. And the other problem is that the special prosecutor specifically argued in closing that the jurors are able to find, six can find one act and six can find another, so there was no requirement that there be unanimity. The state in their response indicated that our only objection at trial to the instructions was the use of the word reckless as opposed to negligent. But as we cited in our reply, and we had to get the trial tapes to delineate that, that was not our only objection. In fact, Ms. Barreras specifically made the unanimity objection, and it's laid out in our reply. There are different ways in which crime can be committed. That's when, Your Honor, we are in this case, which Taylor talked about, when there's separate theories and those have to be unanimous. So that's why I submit to the court that Godoy is not applicable, that the principle of Taylor is applicable, that we need a unanimous verdict on the specific act. So that's why I submit to the court that Godoy is not applicable, that the principle of Taylor is applicable, that we need a unanimous verdict on the specific act. And so, Judge, I submit because of that, and none of us had the Taylor opinion at the time, but now that we do, I think this is a reason that Ms. Gutierrez-Reed should be entitled to a new trial with instructions that are different, that follow Taylor and they track Taylor's language, requiring a unanimous verdict on the specific act that she alleged to have committed.
Prosecutors argued that she was responsible for the incident by loading a live round into Baldwin's prop firearm in the first place. Through witness testimony from crew members, text messages between the armorer and others, testimony from law enforcement personnel and firearms safety experts. The state convinced a jury that Gutierrez-Reed was negligent in her duties on the film set. During Friday's hearing, they responded to the defense with their own set of arguments.
It's my recollection that in closing, what I invited the jury to do, and this is a little bit different than what Mr. Boles is suggesting to the court. What I explained to the court is you've got 12 and 12A. And between instruction 12 and 12A, there is unanimity is not required. I don't believe that I suggested to the jury that the options within 12A did not require unanimity. That's my recollection of my closing. I can see Mr. Boles shaking his head. We haven't had the reason that when Mr. Lewis filed his response and he indicated that the defense didn't object to this was because he didn't have the benefit of the audio and the transcript. And that's one of my concerns is the defendant had the benefit of the audio and the transcript when they filed their initial 2-page motion, but they certainly haven't shared it with us. So I'm happy to provide additional briefing on this if the court thinks that that's necessary. So while I appreciate the fact that the Taylor case may give guidance in the future to how to properly construct jury instructions that have and/or separators, the Taylor case actually has language that specifically supports what we did in this trial, there only being 2 options in 12A separated by and/or. So I'm a little confused about what the defense thinks the strength of their argument is, because when you read paragraph 14, Taylor actually is supportive of the way that we did it in Ms. Gutierrez's case. So for those reasons, we would object and we would ask the court to deny defendant's motion.
The specific language in 9 and 16 is the console case when 2 or more different or inconsistent acts. That's specifically stated. And that's what Justice Vigil is saying in Taylor, is that the unanimity principle is the problem. The unanimity principle as to which different act. So it doesn't matter if it's 4 or 6 or 8 or 2. It's the idea that under our Constitution, there has to be a unanimous verdict as to the specific act. That is the issue that Taylor is stating. Now, I agree that Ms. Morrissey is correct in 14 that they talk about 2 or more, A or B and C. Now, the reason why they were going into that is because they were emphasizing that here we not only have 2, we have 4, which made it more confusing. So it was more confusing in Taylor under those specific alternatives, but it didn't change the principle they're announcing, which is that when 2 or more, it has to be unanimous and it has to be separated.
After both sides laid out their arguments on the matter, Judge Mary Marlowe of Summer gave her ruling.
I'm very aware of what occurred at trial. I'm very aware of the discussions that occurred on regarding the jury instructions. And I am denying your motion, Mr. Boles, because I do not think that Taylor requires a new trial. In this case, I think that the issues in this case, the jury instruction in this case, are distinguishable from what happened in Taylor. I'm going to provide a written order outlining my reasons so that there's no misstatements of what I'm to make an oral determination.
As for Gutierrez-Reed's immediate request for release from custody, here's what both sides had to argue and what the judge ultimately ruled.
Which was to consider release of Ms. Gutierrez-Reed pending an appeal and a writ that we would take for guidance from the appeals court and Supreme Court. And I just wanted to add to that, She didn't have any violations pending trial. She takes care of her father, who has been diagnosed with leukemia. She works, and she has been in counseling. So she hasn't done anything wrong. She's not a danger or a flight risk. And I think there's an appellate issue that we have stated that we will raise, and a potential Supreme Court writ. And I just think it's unfair if there's any chance of the Court of Appeals or Supreme Court seeing it differently, that she serve her whole sentence on the chance that it could be.
I mean, I actually asked Mr. Boles for proof of Ms. Gutierrez's employment history during the time that the case was pending, and any counseling and treatment that she has completed or participated in. To date, I don't believe he's provided me anything. So while Mr. Boles wants to make these statements to the court this morning, these are things that I requested from Mr. Boles, I think, over a week ago. I did it almost immediately after the trial so that I could be thoughtful in terms of coming up with a sentencing recommendation at the sentencing on April 15th, and I've received absolutely nothing. In terms of Ms. Gutierrez's full compliance with her conditions of release, I think there are some arguments to be made there if the court wants me to make them now.
The jury found Ms. Gutierrez-Reed guilty. She is incarcerated at this point. She's facing incarceration time. Keep in mind, there was a death that the jury determined was caused by her. So I am not releasing her.
Halyna Gutierrez-Reed's sentencing is scheduled for April 15th, where she faces up to 18 months in prison and a $5,000 fine. And between now, that sentencing date, and Baldwin's upcoming trial in July, anything could happen. So we'll be sure to bring you the latest in the Rust movie set saga out of Santa Fe, New Mexico, from gavel to gavel. You're watching Law and Crime.